Brandon put it in the chat over here for
Yeah.
Now you're dealing.
These motherfuckers, man. Oh, they now that they
In writing, like we talked about a bunch of times, you can pretty much but that doesn't happen always. You don't always get that easy, in writing saying like, okay, we've got a problem here.
okay.
Another good one from Thomas. Thank you, Thomas. Oh, guys, let's say we decided that this debtor is in fact,
You gotta love it.
as they claim, they are a sovereign citizen. Are they not giving up their rights of protection under FDCPA?
Yeah. I mean, the answer is
Yeah, the
yes.
woke
But
and
that's what I
broke
was
are.
saying.
They not talking about us. They
They're
talking about
not
the
really
woke and broke.
proactive,
They don't
in
know
my
no better.
experience. They're not really proactive in employing the courts to prosecute claims. They're more reactive
Yeah,
in
that's the woke and broke.
using their sovereign citizen
Yeah,
status to defend claims and claim they're not owed.
We get active out here. Yeah, we're not just reactive. Yeah, the woke and broke, yeah, they're just strictly reactive. Right. There's a difference. Right. Yeah, no, we gets active. It's a big difference.
And that coupled with the fact that I really don't think most of them care about $1,000. They really just, in my experience, they don't. It's way more about the game, and it's way more about the system screwing them, and that they're the smartest person in the room, and they want everybody to know that. And so it doesn't really bear any reality on them getting $1,000.
Yeah, we won't be paid.
So
we don't care about all that. We won't be paid.
Care if you pushed back on them and said you are giving up your rights under this federal statute.
Yeah, we choose paid over right.
That Congress doesn't have anything to do with me. I don't have anything to do with that Congress. Here are your coffee beans. I'm done.
Yeah, I don't see much. Yeah, I don't see much of them. I don't know. Wade, do you? I don't see much of them just bringing it. Like I said, in the police context, I've seen it because criminal charges. Then all of a sudden they go after everybody to try to get rid of the criminal charges. Same way with here. You sue them on the account. Then I can see. Then they come back. They may come back and assert something because you sued them on the account.
What they gonna
You
assert?
could be dealing with it then, but yeah, I don't see. I don't. Maybe they wouldn't come up on litigious debtors.
They're more like constitutionalists. They say, they'll try to invoke constitutional rights despite being a sovereign citizen, which makes no sense. I get it, or they'll just challenge all authority. That's how they sue. In my experience, that's how they sue everybody. Is they say the courts have no authority over me, therefore you've conspired with the court and a declaration of my rights from this court who I do not acknowledge, and that you have no rights over me. So
they love the conspiracy. They love a conspiracy claim between all the attorneys and the parties and the judges and everybody involved. Yes, they love to throw that in.
All right, so speaking of the courts, guys, we kind of referenced earlier, you can Google or go to YouTube and watch some fun body camera footage of traffic stops, right? But sometimes in those footages, you see the person get arrested, or perhaps you are dealing with a consumer and you have not made any contact with them. They have not made any responses. You've held the debt for X number of months, and your processes now are to go ahead with judgment, right? And it wasn't until after the judgment was filed that it comes out of the woodwork that this is now a sovereign citizen. What happens in these cases, these traffic stops, these judgments that you guys move forward with? What are the courts doing nowadays when these judges are presented with this fine human being to deal with?
I'll end. I've seen a very, very clear trend in the last 5 years of the courts getting so sick of these guys and they're really fed up. They treated them like pro se's for a long time and gave them the benefit of a lot of doubt. And let me say,
Yes.
I'm talking about putting them in your rearview mirror and not engaging with them.
Yes.
If you sue somebody and you get a judgment, these people, you can garnish them. It's not, there's no reason why you can't. If you have a judgment, I'm not suggesting that you should not pursue a judgment. I'm just telling you, when you tangle with them in court, they tend to throw all this crap back at you. But boy, I've seen debt buyers, debt collectors get judgments, big judgments, and then that's when these guys go crazy, and they because you're about to take all their money, but not all their money. You're about to take money from them. They start judgments. They do not get out of these judgments because of this. It's just, if you don't have a $15,000 or $20,000 judgment, and you're talking about a smaller judgment, you're gonna pay Jeff Turner a lot more to enforce to.
Property, and oftentimes they'll have property, and if a lien gets placed, and they'll say, we don't recognize the lien. Well, okay, well, a lien's a lien. I mean, the courts
Once you get through that first phase, because then once they've lost, they lose. I mean, you can collect them. You can
I'm with Justin. I don't. Yeah, once you're down that road, I don't think there's anything wrong with that. I just, once you're to that point, you're through the battle for the most part because you've got the judgment.
Don't leave the battlefield. Stand your ground.
Speaking of, again, getting it to a potential area of judgment, right? Everyone's collecting balances of all kinds of sizes. We know that certain balances are just simply not worth taking into judgment, right? But you might have a very large ticket item, and someone owes you $500, you got to write it off because they're sovereign citizen. You don't want the headache. That's probably not that big of a deal for a lot of folks out there. Turn the page on that guy, catch the next fish. But when you have large ticket items, is there any kind of threshold for you guys that would say, you know what, we know who we're dealing with here, and it is going to add some complexity or potential challenges, but this is a $50,000 balance or whatever that number is for you. Do you have any recommendation for the folks listening where that ticket's way too big to not pursue and not to throw away because they're making these sovereign citizens claims?
You talking about a judgment, or are you talking about in like collections?
I guess both, right? Maybe your office doesn't go forward with legal matters, right? But it's a large ticket item, and on the first consumer agent interaction, they kind of express, "I'm a sovereign citizen." Do you ignore regardless the ticket size? We will not deal with this guy, or man, this ticket's way too big for us. We got to make our best effort here.
Might be a weight question. Is that?
Yeah, that's almost way. Do you have a threshold?
I don't want to throw you out
threshold.
there.
I don't think there's a threshold necessarily. I think it's still, you should still look at it as like a business decision, right? Like do you have some evidence that this is someone who has the ability to pay? And if the answer to that is yes, and they're a sovereign citizen, there's going to be some dollar amount where it is probably worthwhile to move forward, but then it kind of vary jurisdictionally in terms of, based on your relationships with debt collection law firms, maybe you have in-house attorneys, the cost to your organization to get tied up in one of these is going to be very different if you have either an in-house attorney who can handle the litigation, or if it's a kind of an outside collection law firm relationship and you send them a lot of business, you have pretty favorable kind of rates with them, versus maybe it's a jurisdiction where it's just really expensive to litigate. You're paying the debt collection law firm like roughly the same percentage that you get from your creditor client. Like in that case, that margin that you're making is not going to be worth the dozens of hours that you're going to have to throw into this particular case if it explodes. And so I think it's probably something where you're evaluating a lot of factors. So it's really hard to come up with a specific amount in terms of like, if it's $25,000 or more, go ahead. I think it's typically going to be more, you need to factor in, here's how much time I could potentially have to throw at my collection lawsuit, which is going to have counterclaims, which is
Yeah.
probably going to have like multiple hearings throughout the case because this
Yeah.
person's going to continue to file nonsensical documents. It's in state court. The
Irritated.
judges are probably just going to calendar random hearings to try to deal with it. You're going to have one case in the appellate court. You're going to have a second case probably up to the Supreme Court. And so, if you're kind of evaluating all of that and you have the resources from an attorney perspective to be able to handle that and do it in a like relatively, cost effective way, then I think it's probably something where, if you're looking at like
Yes.
even a $10,000 to $15,000 file, it might be worth it, right? If it's in a state where it works out well for you financially to litigate. But if it's something where it's not one of those states, then you are probably, there may never be a dollar amount where it's really going to make sense for you. So I think those are probably the types of considerations you're going to want to look at to kind of come up with your own sort of schedule or metrics in terms of like, we want the dollar amount to be this in order for us to move forward on a case like this.
So Wade, I wanted to say this though. Hang on one second, just because I didn't want to say this because I don't have the frontline experience on collections. But my gut on this, which I think is confirmed just by what you said, Wade, my gut on this is you need to approach these people with the assumption that they are not going to pay unless you get a judgment. Like, I think
And that's exactly why they continue to get unlawful acceleration claims. That's exactly why. Yeah, that's exactly where that comes in at.
that's my guess,
Thank
but it's
you.
a fairly educated guess. And Wade, you in your answer, you sort of said everything
Because
you
they
said
just
presumed
go
that you're
to
going to court
they
to get a collection judgment. Is that your experience?
they skip the opportunity to cure and just go to judgment. Yeah, that's unlawful acceleration. Yeah, so that's what they do. That's why they keep getting those claims, because consumers now understand what that is. A lot of consumers weren't aware.
You're just not. I don't think you're going to do real well with a collector calling and saying, "You owe $50,000. Let's get in a payment plan." They're not going to. You got to get a judgment. So, and then I think really important is the good hygiene there. Is this collectible? Does this person have assets? Is this
No,
worth it?
and that's why I think you can actually do something with the judgment.
Yeah, exactly. So, but the takeaway, a big takeaway there is, I don't think short of a judgment, I don't think you're going to get a lot of traction on payment.
Right.
But if you're on the verge of whether to sue them or not, it's something this is an account we would typically sue on, or maybe it's close. But if this is sovereign citizen, then no, because we're right on the edge. We're right on the edge.
I've not seen a lot of sovereign citizen enter into voluntary payment plans. That's just not.
That might be one of the keynote takeaways right there. So guys, we got about 10 minutes left. We want to make sure we end on time for our guests. We probably can do 2 more questions, and then of course we always want to wrap up with some of your finalized thoughts there. So speaking of making decisions on pursuit, or what about for if you guys have internal experience, or for our agency operators out there collecting on some third-party debt, and you have that paper and it becomes very clear that this is a sovereign citizen, maybe this person doesn't have assets, or the balance is not quite large enough to take into a judgment process. And some of our lovely clients like to think that we're supposed to collect everything they send us, right? So any advice or any experience where you've had to send a file back because you said this one's too hot to handle, juice is not worth the squeeze, but then you get the client kind of kickback saying, what do you mean you won't collect this debt? And perhaps they don't understand that situation. Any advice or any anecdotal experience that you can share about that?
Well, we might have to kick that back to Wade.
Ways
Right,
to do
as
it.
well.
Whate's the only
Because he's on the
collector
front line with the collectors. Yeah,
Right.
yeah, right.
Yeah, I think part of that it probably starts really early on in your relationships with your clients, like the onboarding process of just setting realistic expectations, right? I think that everyone has had those types of clients where they view it through the lens of like, well, I don't really care. It's not my money, right? Like, you should have to send this many letters, make this many calls. And it's like, if that puts you in some sort of negative financial position, like not my problem. It's like, well, but it is your problem. Like you're contracting with us to use our skills and our expertise. You obviously want us to stay in business and doing the types of things that, you know, you're kind of alluding to here. This is a good way for us to go out of business, right? Like the reality is every organization in the world has a finite amount of resources, and we want to collect the most money for you possible while generating the fewest number of complaints or issues possible. Because when those issues pop up, like you get one of these people who are filing these types of cases, there's nothing prohibiting them from sending discovery requests to your clients or trying to depose your clients. And so, you know, that all of a sudden becomes a file that now they're having to invest a lot of their time into it. So I think we've always tried to sort of explain it to the clients in that way, where it's like, it's not just about collecting the most dollars possible. It's about doing everything we can to preserve the most favorable image that you have within the community that we possibly can. And so there's multiple layers to it, or different angles to kind of approach it. But that's the way that I think I've always tried to kind of address that type of issue.
Yeah, and you have all the data, right? I mean, you have there's an element, you don't want to push back too hard on your client.
Right.
But you have the data to be able to say, you're paying me for my expertise. Part of my expertise is this giant amount of data that I have gleaned over all these years. And I'm telling you, this is not worth this is not worth our time. It's not worth you're paying me to do this. Let me do it. So I don't, the one thing I would say from the front line that Jeff and I are on in defending when there's a lawsuit, this wouldn't necessarily have to do with sovereign citizens, but I would be careful what you paper your client back with on a file like that, because if they end up getting sued for something later and you've made it very, very clear that you believe this person will never pay, you just need to be a little careful what you say in the notes that go back, because if you might be that might get distorted 3 or 4 years later if that debt has gone back active somewhere. Just be mindful of what's in those notes when you send them.
Good point.
Good point. Maybe a personal phone call from the customer service agent.
Yeah.
Hey, I just sent you a file. Look up this guy named Justin Penn, and you guys mark a note here.
As Wade said, one good point there is you talk to the client and say, the next thing you know, we're all going to be involved with a mess with this guy, including the creditor client. They don't want to hear that, and they don't want to get involved in that.
All right, guys, we're going to end on, should be a pretty quick question, but Corinne makes a funny comment here. Someone signed a letter, the commander of the Space Force, and that helped her client understand that this guy is not worth collecting. And Hunter put a really nice definition of sovereign citizen in there. But Hunter, you've been great. You've been asking a bunch of stuff. So question from Hunter. In my training days, I came across a YouTube channel. I won't mention his name. He's one of the fine consumer attorneys out there that some of us might know, but he had a YouTube channel for a while and would call out a bunch of agencies, and he was well known for providing information to consumers, and we see the TikTok vids and all that stuff nowadays. But Hunter's kind of asking, obviously everyone can Google and chat GPT, but do you guys know of any like centralized kind of formats or online spaces that these communities exist, or if any of our listeners want to go and self-educate and learn what these folks are all about? Do you guys know of any central communication point that these folks gravitate towards?
I do not. I think you'd have to get in with a group. I don't. I think they probably try to fly under the radar as far as some online presence. I would guess. I don't know.
I mean, I have assumed that it's largely TikTok and YouTube, but I've just assumed that, I guess, because that's where I see the videos of the sovereign citizen traffic stops. I would have, if you went on Reddit, I bet there are thousands of these.
Yeah. Somebody just said Reddit. Somebody just said Reddit. Yeah. Tons.
I don't use it.
I didn't think about that.
Reddit would be probably pretty big, but the videos are what takes off. If you Google sovereign citizen, you're going to get mostly videos of traffic stops or interactions with cops. That
Instagram, Reddit. Yeah, you're
yeah,
gonna see
I don't do
it.
Instagram, so I
There's
don't,
probably a whole
I just-
subreddit.
yeah, I'm sure it's all over Reddit. I would guess
Yeah,
it's
there you
all.
go. Sure.
And AI
All right, guys.
not from Reddit, so if you do AI, you're gonna get a lot.
Sure thing.
Maybe one interesting fact is I've been running a lot outside of work, and I'm currently training for a triathlon this June.
Oh, nice. What is your best event in the triathlon?
I'd like to say it's cycling, but I think just
Yes,
finishing
I
a
do,
race is
baby.
probably enough of an accomplishment
Here,
for
email
now.
me.
Is the triathlon in Richmond or somewhere else?
It is in Maryland.
Nice. So tell the listeners, John, a little bit about your practice, what you tend to focus on from an FCRA perspective so they can know where you're coming from.
Sure. I've handled a couple different kinds of FCRA cases for clients here. The first are Section 1681 S2B claims, which is the kind of case that we're talking about today.
There you go.
I've also handled cases regarding whether a user has a permissible purpose
You
to
can use
access
that one.
someone's credit report, and also
Use
just a
that.
handful of furniture type cases that also come under the statute.
And you've also got a significant background in white collar and government investigations, right?
That's right. I've been an attorney going on 6 years. And for the first 4.5 years of practice, I was a white collar and government investigations defense lawyer with another firm.
Got it. All right, so let's dive right into Kurtz. So I'll just give the listeners a little bit of background on Kurtz. The plaintiff is Reginald Kurtz. Mr. Kurtz obtained a loan from the Rural Housing Services, or Rural Housing Service, which is a division of the Department of Agriculture. And of course, the Department of Agriculture is a federal agency within the executive branch. Mr. Kurtz pled that he paid,
Remember, even in those times.
and at the district court, he alleged that his credit report showed the account was closed with a balance of 0. However, the USDA continued to report the payment status as the account being 120 days past due. For those avid
right
listeners, you
above
know
you.
the payment status was a significant point of litigation in many circuits, including
There
the
you go.
Third Circuit, in terms of whether the payment status historically was a historical element of data or a current element of data. But that's another episode. So plaintiff and Kurtz argued that the credit reporting was false on its face because the account could not have been simultaneously closed with a 0 balance and also be past due. So we disputed the credit reporting with the agency and alleged that both the USDA and the agency had failed to undertake a reasonable investigation and update the status of the account. And so, as often happens, he filed a lawsuit against the Consumer Reporting Agency at issue and the Department of Agriculture in October 2020, alleging that the defendants had violated Section 1681 S2B of the Fair Credit Reporting Act. And so, John, I think that's a fair catch up to where we are. Let's talk a little bit about the background of the FCRA under S2B that gives rise to these claims, maybe for listeners who haven't been doing this for a long time.
Sure. Well, the Fair Credit Reporting Act was first set up by Congress in 1970. And under the original version of the statute, it created duties for credit reporting agencies,
Okay.
charged them with ensuring accuracy and
Yeah, it's okay.
confidentiality
Go
of
ahead.
consumer information. And the statute also focused on users of credit reporting information, which it defined as, quote, persons. And there it was talking about the people that basically rely on credit reports to make business decisions. Again, back in 1970, person was originally defined to include any individual, partnership, corporation, trust, estate, cooperative, association, government, or governmental subdivision or agency or other entity. So again, pretty broad. And under this original version of the statute, consumers were authorized to seek damages against credit reporting agent reporting data. Skipping ahead a little bit, we kind of rejoined this story in 1996. In 1996, Congress passed the Consumer Credit Reporting Reform Act, which created new duties on, quote, furnishers of information. So those new duties set forth the modern approach to claims asserted under 1681 S2B. So in general, and frequent listeners will be very familiar with this process, if you're a consumer and you believe that you have something that's inaccurate in your credit report, the statute sets up a dispute process where you can contact the credit reporting agency. They're going to investigate. They send the dispute over to the person that originally provided that information. And then the furnisher is supposed to investigate, review all the information that's provided. And if they discover anything is false or needs to be updated, then the statute requires them to do so.
All right, perfect, John. Thanks for the background. So let's just skip ahead to the basis of the arguments at issue in the district court. We don't have to cover the entire case in detail, but just at a high level, what was the issue the district court faced with respect to the government's motion to dismiss? And then we'll eventually get to the Supreme Court.
Sure. Well, Mr. Kurtz filed suit in the Eastern District of Pennsylvania, and he named the Department of Agriculture as a defendant. And the government came in to represent the Department of Agriculture and filed a Rule 12b1 motion to dismiss, arguing that the federal government had not waived sovereign immunity under the Fair Credit Reporting Act.
Meaning the federal government took the position that it could not be sued in a private cause of action, right?
That's right. And the basis of its 12b1 motion to dismiss is that the court did not have any subject matter jurisdiction to decide Mr. Kurtz's claim. So the case comes before District Judge Mitch Goldberg, and he kind of wades into this issue and sees that there's a pre-existing circuit split on whether the government has waived sovereign immunity in the context of the FCRA. On one hand, you have the Fourth and the Ninth Circuits, which hold that there is no sovereign immunity waiver. And on the other hand, you have the Seventh Circuit finding that there is a waiver.
So let's dig in a little bit. The district judge highlighted the circuit split. So what were those differing opinions in the circuits and what were they based on?
Sure. Well, in the Ninth Circuit, the court kind of looked at the potential results that would occur if the government was able to be held liable under the FCRA. Would occur if you read the term person to include government agencies.
You're referencing person because person is definitionally part of the FCRA's definitions, correct?
That's right. So the statute authorizes basically damages against any person who fails to update their credit reporting in response to one of these disputes. And under the original version of the FCRA, the statute contemplated criminal liability, but not civil liability against a person. So when this same dispute came before the Ninth Circuit, that court said, if you read a person to include the United States, your position is that when Congress wrote the law, it intended to waive immunity only for the purposes of criminal prosecution, which would be absurd in the Ninth Circuit's telling. So break that down a little bit. They're basically saying one government agency or the Department of Justice can go out and hold another branch or division of the United States government criminally liable under that interpretation of the statute, and that's absurd. And relatedly, that position also creates the possibility of punitive damages being assessed against the government, and that did not withstand muster.
All right, so to cut to the chase at the district court, John, ultimately the district court granted the government's motion to dismiss, finding that the government did have sovereign immunity to be sued in an FCRA case, correct?
Yes, that's right.
And then we get to the Third Circuit. And why don't you talk a little bit about what happened at the Third Circuit before we get to the Supreme Court?
Sure. Well, the Third Circuit unanimously reversed, and it started its opinion off with, I thought, an interesting sentence, which says, there are profound implications to throwing open the doors to the United States Treasury. So before we do so, we need to be sure that is what Congress intended. And so that kind of header line is referring back to the possibility of punitive damages being available to private litigants who sue the government. And here, I think the Third Circuit panel set aside some of the absurd results that were prominent in the district court's reasoning, and it focused on the language of the statute itself. It lists government or government agency as a person. So if you apply the traditional rules of statutory construction, and the first thing you do is see if it leads to ambiguous results. If the results are not ambiguous, you simply apply the waiver of statutory immunity or sovereign immunity as written. If the result is ambiguous, then courts are freer to consider the possibility of immunity.
And so what did the Third Circuit ultimately decide before we got to the Supreme Court?
Well, it took a look at some of the arguments that the district court found persuasive and ultimately rejected them. And as I said, unanimously overturned the district court opinion and permitted the suit to go forward.
Against the government agency.
That's right.
So we eventually get to the Supreme Court, and it turns out to be a 9-0 decision by Justice Gorsuch, correct?
That's right.
So ultimately, what did Judge Gorsuch decide, and really just turned on the definition of person under the FCRA, right?
That's right. I think I'm used to reading very long Supreme Court opinions, and this is not one of them. I think we get to the bottom line by page 7 of the opinion, and reading it, you really have a sense that the court is almost incredulous. I think pretty much everyone understands that we have a very text-first court. That court looked at the statutory definition, it looked at the architecture of the statute, and basically concluded very quickly that the FCRA does contain a waiver of sovereign immunity. And for that reason, the government can be sued.
Yep, makes sense, especially when you look at the textual court and the use of the word person and the way the statute defines person. So a lot of our listeners are probably not working for government agencies and probably not working for the U.S. Department of Agriculture. So let's talk a little bit about practical impact for private entities now that the government can be sued under the FCRA. Because a lot of times our listeners are just looking for takeaway messages. I actually found one of these takeaway messages pretty quickly after the decision. I was litigating a case for a consumer reporting agency. We were trying to reach a settlement related to the reporting of a loan that involved the U.S. Department of Education. And the plaintiff's counsel in that case ultimately agreed to our settlement number because he said, well, shoot, I can now go to the U.S. Department of Education and get whatever money I'm not getting from your client. So I think one of the most significant practical impacts for our clients and for private parties is that there's now another pocket, and remarkably a deeper pocket than what a lot of plaintiffs' counsel think our clients are. So one takeaway is if the case potentially involves the government entity, plaintiffs' counsel may conceivably be more willing to settle quicker if they think they can go after the government who's got a deeper pocket. John, what do you think the other takeaways are from your perspective for private parties?
Well, I think there's a big one, which deals with basically how the federal government reacts to adverse decisions from the United States Supreme Court. And a few years ago, one thing the Supreme Court did was find that a statute of limitation applicable in the securities context applied to the United States Securities and Exchange Commission when they were going out to seek remedies. And in response to that, the government wanted to do pretty much as little as possible to preserve their rights as much as possible. And so what it started doing was requiring private litigants to sign tolling agreements much earlier in the investigative process. I think in this context, the overall approach is going to be somewhat similar. The government does not want to create additional exposure under the FCRA to the extent that it can be mitigated. And the easiest way for it to do that is to limit the information that it provides to consumer reporting agencies. So one possible reaction here is that the government is going to reduce the amount of information that it supplies to the ecosystem. And the net effect of that would be to degrade the information that's available to users of credit reports. And so there would be, in a sense, less information available when a business is making a decision whether to write an insurance policy, whether to extend credit, and for all the other uses of a credit report.
Yeah, I think that makes sense, and I think that's probably likely to happen. Two other ramifications I was thinking about when the decision came out is one, are clerks' offices more likely to get sued now? Because so many of our cases in the tenant screening space and the employment screening space relate to the accuracy of information coming out of the courthouse. So is it possible we'll see disputes to local courthouses?
No one loves like you do.
But it's the thoughts in my mind.
So many things for the whole
Billionaire.